back, there was I wasn't sure what that sigh was. It was almost as if maybe she was hoping she wouldn't return, or I wasn't sure about that.
Yeah, I think she was surprised, for sure. The jurors all along were asked to forget what they had heard before coming to court. So I think that her thinking about it was smart, but she wasn't being asked to do something that she already wasn't being asked to do. She was being asked to forget that she ever saw the video of the events that unfolded last year with George Floyd and Derek Chauvin. So she's already been asked to forget what she knew. So I think that it was, not surprising.
Yeah, and that takes me to my next question. I don't know if you noticed it. One of the reasons I wanted to juxtapose those two was because there was a seemingly different approach that the judge took to both of those jurors. And I want to know if you, before I tell you what I think it was, I want to know if you noticed anything.
Well, I did notice that they took a different approach. I think that I don't really know why, but I do know that she did preface everything by saying, I thought about it, to acknowledge to the judge that, she was prepared to address it. Where I think that the other juror didn't really express that kind of acknowledgement of it, having to think about how it would play out.
But I'm talking specifically about the way the judge tried to rehabilitate them. I thought for the first one, the male, he didn't dig deeper, because I agree with you. They've been asked from the very beginning to sort of disregard some of the things they've heard or read or seen, and nothing could be worse than that video. And finding out that there's this settlement, he dug deep with number 44, the second, the female, and really went in and said, well, it's a very different situation, different parties, different law, doesn't have anything to do with this case. And I felt like if he would have done that with number 20, he could have kept him on too. And again, I'm not saying that they had a real reason behind it, but I noticed that there was a difference there.
There, now that you mentioned that, there definitely was. And maybe that was because he was further into the process and realized that maybe he should try to rehabilitate. I think that she was the last one to be questioned this morning, if memory serves. I could be wrong on that. So he might have been worried about losing jurors, and maybe he thought he should have tried to rehabilitate the other. So I guess that could have been him second guessing himself.
Yeah, that was actually my thought. I thought he was refining his approach to these jurors, realizing that I can't keep getting rid of jurors. It's clear that these folks have heard about it. It's hard not to hear about it. And I got to find a way to keep them. And I don't think it's a bad thing. I mean, let me get your thoughts on this. If you were the defense attorney in this case, and a juror heard about it, right? And the judge rehabilitates them in the way that he rehabilitated number 44, who seems like an intelligent, thoughtful person, and he explains to her clearly the situation. I'm not sure it would bother me too much. I think people can separate those two things.
I think that they can. I find myself, when I'm in that position, that I tend to get a little frustrated with judges that work really hard to rehabilitate jurors. Once they've expressed that something has moved them in one way or the other. I don't think that this particular juror that we're talking about, the juror number 7, I believe she is now, I don't believe that she was expressing that had turned into a bias for her. She was recognizing that it was something separate, and that she even said that they were doing this before hearing the facts. So it was almost like she was recognizing, and she said something else that was very striking. She said that the city had already taken steps to defund the police. So I think that in her view, this was a political decision about the mayor trying to defund the police more than it was a decision about the facts of this particular case. So I think that her responses showed a clear separation from the dollar amount and what that meant in terms of guilt or innocence of Chauvin.
And I think that's an excellent point, a very fair point, because juror number 20 did say that he had sticker shock by the number when he saw the number. So that may have sort of affected the way the judge handled it. Now, we saw today that the judge, as a result of some of these issues, he gave back some peremptory strikes, 3 to the defense, 1 to the state. But he's also still has under advisement this change of venue and this continuance motion. Where do you think those should be? Do you think either one of those will change some of the issues and problems that the defense is having in this case?
I thought about this a lot today, Michael. I think that the defense has a big problem with whether or not Mr. Chauvin can get a fair trial. And will we ever know if he can? I don't know that changing the venue will change what people's views are. This just permeated this country in a time that we were all pressing pause anyway because of the pandemic. I doubt that any American has no view or a completely neutral view on this case. I think that people think that they can separate it. So I don't know that a change of venue is going to make any real difference. I think that the addition of the peremptory challenges was very fair, and I think that he probably should have done this Monday. I'm not sure why he didn't, because the peremptory challenges, you use those strategically as a lawyer. You're seeing the jury questionnaire, you know who's coming up when, and you have a sense by reading that questionnaire where the prosecution is going to be going with their peremptory challenges before you even have an opportunity to question those witnesses. So, he strategically had used some peremptory challenges that he might not have used had he known that this had happened, this bombshell dropped on Friday. So I think that the addition of the peremptory challenges helps to cure any defects and allows them to go through some additional jurors before that. But I also think that, these cause challenges are still important. And this judge is very liberal with his granting of cause challenges. He's not, being stingy with them. He's recognizing that Mr. Chauvin needs this fair trial, and I think he's doing a really good job with that.
Yeah, I couldn't agree more, and you're absolutely right that most people have an opinion. A lot of folks I come across on social media feel one way, and I keep having to remind them that, no matter how you feel about this, the defendant in this case deserves a fair trial. All right, Christa Ramey, I want you to stand by right now. We do have to take a break.